I will issue a warrant for your arrest if you refuse to attend in person.
Can you please stop referring to me as a defendant?
Ms. Christian, I got to tell you, I don't know what in the heck you're talking about.
Because I really don't want to have to file claims and ruin people's lives and ruin their jobs because they're not upholding my constitutional rights as a woman, not a defendant. I am a woman only. I, woman Angela. I, woman Angela. I, woman Angela. That's it. Not defendant. I don't want to file claims. I'm trying very hard, and I've been trying hard to not do that. But I guess if we got to keep going, that's my next step.
Can you hear me?
Yes, I can hear you.
All right. Good morning. We are back on the record in the 53rd Circuit Court for the County of Presqu'île. And Ms. Christensen, although you're appearing from your home, for convenience sake, it might not feel like a court hearing, but it is a court hearing. So I'm going to ask you to please remove your hat.
Oh, sorry.
No worries. Okay, thank you. All right, so as we begin the hearing, just like last time, I'm required each time to remind you that you do have the right to the assistance of a lawyer if you wish. And that includes the right to a lawyer at public expense if you were indigent, and that you've previously waived that right and wish to represent yourself. And so I guess I want to ask you again, do you reaffirm that you'd like to represent yourself in this matter, or would you like to have a lawyer?
No, I would like to self-govern, and I stand on my paperwork.
Okay, so what we have today, you did file 4 written notices that asked for some type of relief, and we had adjourned the hearing to today for any argument on that. So the prosecutor has had a chance to review them. So Ms. Christensen, you say that you stand by the paperwork, and that's fine. I do have the paperwork in front of me. Is there any argument that you'd want to make on your behalf right now to me in support of those claims, or do you wish to just rely on the written pleadings you filed?
It is my wish to stand on my paperwork.
Okay. Mr. Radsbaum, do the people have any argument in opposition to those 4 notices?
Your Honor, I've reviewed the paperwork, and I guess while she may not recognize or honor the state of the law, I don't believe that there's any relief that's recognized under law that would allow you to dismiss this case against her based on what she's alleged in the paperwork. I fail to see it.
Okay. All right. Well, Ms. Christensen, now I'm going to make a ruling on the notices, which I'm construing as some motion or request for relief. And I've got a written order that I'll enter. I'll read it at this point. Defendant, who at this point in the case is representing herself, has filed 4 handwritten notices. These notices appear to seek relief in one form or another. As to the first notice, defendant asserts that she is a woman and not a defendant. The court finds that Angela Christensen is both a woman and a defendant in this.
This is where the sovereign citizen playbook really collapses. Notice how she keeps repeating, "I am a woman, not a defendant." That's a classic trick they use, trying to separate their identity from their legal charges. The idea is that if they redefine themselves, the court loses jurisdiction. Spoiler alert, it never works. Judges have heard this nonsense hundreds of times, and the law doesn't bend to word games. Honestly, I think the judge is showing incredible patience here. Let me ask you, if you were sitting in his chair, would you laugh or would you throw her in contempt right on the spot?
Her notice seeks relief. Such relief is denied. As to the second notice, defendant demands that any man or woman with a claim against her appear and present such claim in open court. To the extent that this notice seeks to invoke defendant's right to confront her accusers, this court will enforce that right. However, the right of confrontation does not require the complaining witnesses to appear at all pretrial hearings, but only the trial or any necessary evidentiary hearings. So to the extent that this notice seeks to require the appearance of any complaining witnesses at all pretrial hearings, such relief is denied. As to the third notice, defendant asserts that this court lacks authority over her and that only her creator has that authority. Without gainsaying the authority of the creator, it can be noted that religious traditions commonly recognize that the Creator has instituted human authority as well. In this matter, the people of the state of Michigan, through ratifying the 1963 state constitution, as well as its predecessor constitutions, have established this court and its authority. The people of the state of Michigan, through their elected representatives, have established laws that apply in this court. And the people of this county have elected this judge to serve in this office. And this court has subject matter over this felony prosecution and has personal jurisdiction over this defendant. Any relief sought by this notice is denied. As to the fourth notice, defendant claims that this court and the government exist only because she allows them to exist. To the extent that this assertion reiterates the proposition that our constitutional republic is founded on the consent of the governed, such proposition is axiomatic as a general matter. However, this proposition does not require that the government must obtain consent or permission from each individual person before exerting governmental authority over that person. Such an idea is nonsense and would result not in a constitutional republic, but in anarchy. This defendant's views would render all the criminal laws null and void, which is legally and practically absurd. Therefore, any relief sought by this notice is also denied.
And there it is, one of the most important rulings of the day. The judge takes her 4 notices apart like a house of cards. First, yes, she's both a woman and a defendant. Second, witnesses don't magically appear at pretrials. Third, the court absolutely has authority, both legally and constitutionally. And fourth, no, the government doesn't need her personal permission to exist. That's not democracy, that's anarchy. What I love is how the judge explains this with calm logic, almost like he's teaching a civics class to someone who skipped school. But do you think explanations like this even get through to sovereign citizens, or are they too far gone in their own world?
All right, so Ms. Christensen, all of the claims and papers that you have filed, I have found to be lacking in legal and factual merit, and I have denied any such relief. And I'm entering a
That's
order
fine. Can you please stop referring to me as a defendant? And I guess the next step will be, I guess I got to do the actual filing of the claims if you're going to deny all of those.
No, those, I don't know what claims you're talking about. You filed some claims or notices or requests.
No, I did not even file my claims yet. I did notices. I did not file my claims yet. I've been putting that off because I really don't want to have to file claims and ruin people's lives and ruin their jobs because they're not upholding my constitutional rights as a woman, not a defendant. I am a woman only. I, woman Angela. I, woman Angela. I, woman Angela. That's it. Not defendant. I'm not a defendant. In your opinion and legalese, yes, but I am a woman. So do we need to do trial by jury when we can do my claims and file my court with your court at the same time? Because that's going to be my next step, to file claims against everybody involved in this case, because there is no verified claim, and complaints and claims are 2 different things. I don't want to file claims. I'm trying very hard, and I've been trying hard to not do that. But I guess if we got to keep going, that's my next step. And I will file proper claims with the proper people and the insurancing for the bonding. So I don't know what you want to do at this point. And I really don't want to have to do that.
Ms. Christian, I got to tell you, I don't know what in the heck you're talking about. You're talking nonsense. So here's the thing. I am not going to relinquish my authority in this case. I'm not. All right. The prosecutor's office can dismiss the case. They're choosing not to. So that means we do have to go forward to a jury trial unless you want to plead guilty. All right. But what I'm also going to do is your ramblings here today and at previous hearings, and after I reviewed your written notices, it's clear to me that you have no concept of the legal and factual issues at stake. And
I would never know anything about legalese because I never went to school to do the legalese. So I don't understand that part.
All right, you're illustrating my next point, and you have no respect for the authority of the court. You continue to interrupt me and such.
Now this is a
and file
huge
these
turning
nonsense
point.
claims.
The judge just
So I
revoked
am
her right to
hereby
represent
withdrawing my
herself,
consent for you
and
to
that is not
represent
something
yourself.
courts do
I'm
lightly.
referring this
Normally,
man to the
defendants
office
have
of
the
assigned
constitutional
counsel for
right to
appointment.
self-representation.
So any papers you
But here's
file
the
in this
catch.
case, I will reject.
If you show you
because
don't
they have to be
understand the
filed
law,
I don't
can't
accept that
follow
offer,
courtroom
and I do
rules, or
not
make a circus
require
out of the
you to give
process,
me any
the judge can
court-appointed
step
attorney,
in.
and I will
And that's
self-govern because
exactly
that
what
is my
happened.
right.
By rejecting her
I
paperwork
don't
and
want an
shutting down her
attorney. I don't do
interruptions, the
legalese.
judge is
I'm sorry.
protecting
I'm
the
not trying to
integrity of the
be
trial.
rude or disrespectful.
Honestly,
I'm trying to be very
this is the
decent.
legal version of taking away the car keys from someone who keeps
Well,
driving into
I
traffic.
stand on my
What do you
paperwork,
think?
and I'll do the rest
Fair
of my
move?
paperwork.
Or should
I
he
will
have
keep
let her
doing it,
crash
and now I'm
and
gonna
burn
file my
representing
claims, so
herself?
that's fine. But no, I don't need no legal counsel. I refuse that offer. I do not accept that offer. I'm sorry. With all due respect to you, I don't accept that.
Well, Ms. Christensen, it wasn't an offer. So we are scheduling this next for a docket call on February 14th at 10:30 in the morning. And I'll refer it to the Office of Assigned Counsel for you to have an attorney at that hearing. You are no longer allowed to represent yourself in this matter, and you will be in person in my courtroom at that date and time.
I'm sorry, but I cannot be there. I can do it via
Well-
Zoom, and I don't accept that offer either unless you want to compensate me for my gas and my time. Because I can't do that. I can't even afford to. Sorry.
Ms. Christensen, it's not an offer. I want to have you here because you've expressed such disregard for the proceedings. I want to have you here so you can see your attorney. Ms. Christensen, stop interrupting me. It's not an offer. You will be here, or I will issue a warrant for your arrest if you refuse to attend in person. All right, we'll see you February 14th, or I'll issue a warrant for your arrest.
And that's how it ended, with the judge making it crystal clear Angela can't play sovereign citizen games in his courtroom. She tried paperwork tricks, threats, and outright denial of reality, but the law stood firm. He shut down every argument, forced her to have legal counsel, and scheduled her to appear in person. The best part? She even tried to bill the court $86,000 for showing up. You can't make this stuff up. What this case shows is that sovereign citizen tactics might sound powerful online, but in real life, they collapse under the weight of actual law. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.